Oh, by the looks of things, it's time for Legal AF After Dark. I'm Michael Popok. I'm going to tell you all about Legal AF, but better than telling you, I'm going to show you a clip from the most recent episode where we talked about the new appeal that's being attempted by Donald Trump to get rid of Fani Willis, the Fulton County District Attorney, from prosecuting the case against him. They filed an application for interlocutory appeal. Confused you won't be after listening to Legal AF and our breakdown. Take a listen. In Georgia, the, the Judge McAfee on the 15th of March, when he ruled in favor of Fani Willis in a way and kept her in place as long as she cleared the appearance of impropriety conduct that he identified by firing Nathan Wade, the person that she was in a relationship with. He knew that this was going to be something that the other side was not going to be happy with. And he did something different than a prior judge in that same court, the chief judge at the time, Judge McBurney, did about his handling of a conflict of interest and Fani Willis. He disqualified her in that case when she was up against, when the issue was whether she was appropriately supporting a competitor, a adversary for an office for a person that she was also prosecuting. Like she was supporting the Democratic challenger to Burt Jones. There, McBurney, and we covered it here on Legal AF, disqualified her and her office from going after Burt Jones, and it had to be reassigned to a new prosecutor, but did not certify the question for appeal to allow the Trumpers to take that issue up on appeal, because it has to start with the judge in the way interlocutory, and this is where Patreon comes in. We'll talk at length about interlocutory versus final appeals and why interlocutory appeals are generally disfavored. That means they're happening during the case before it's over, sometime in the middle or so. That's the interlocutory. For that, you generally have to ask for the appellate court to give you the permission, and you got to start asking by having the trial judge certify the question for appeal. The trial judge can kill it right there and go, no, I'm not doing that. I don't think you have a right to do it. And if you're going to go ask for the appeal, you're going to have to ask for it without my certification, which is almost never heard of. Here, McAfee certified the question and put enough in his order that gave the defense a lot to argue about the grounds to get the interlocutory appeal granted. There's two in Georgia, unlike other states, there is an intermediary court, but it's really one big intermediary court called the Court of Appeals that sits under the Georgia Supreme Court. The Court of Appeals level is 15 judges. There's a chief judge, Judge Mercier, who got appointed in 2023. She actually, not the clerk, picks the panel, the 3-judge panel from the 15 that's going to hear this case, and she could put herself on the panel. They then evaluate what's been filed by Trump's lawyers and the other 7 co-defendants, which is an application for interlocutory appeal, which is a long-winded way of saying they have to ask permission to have the appeal granted. Now, they cited there's 3 major ways to get an interlocutory appeal granted. You have to argue that there's a lack of precedence that guided the trial judge and he needs instruction. And that's one of their arguments in the area of these are all unique Georgia terms. What is forensic misconduct by a prosecutor? What is a structural error? These are all, again, unique to Georgia, but they're similar to other states. So they argued that there is a lack of precedent and that this trial judge needs more guidance in the area of what is a forensic misconduct as he applies the facts to the law. And then they also argued that he's just wrong, clear error, reversible error, structural error, whatever you want to call it, because in his fact finding, which they're not generally challenging because it's hard for them to challenge fact finding by a judge on appeal. They're saying the fact finding is fine. He just got to the wrong result. On the law, he should have disqualified her for appearance of impropriety or for actually finding that she had a financial stake, meaning actual conflict. And so that was their challenge that they have now put before. And it's going to be up to this Judge Mercier, the chief judge, to assign a panel, the panel to review the appellate application. But of course, there's going to be the opportunity for the Fulton County District Attorney appeal lawyers to file their opposition brief. So this will all be fully briefed. First issue that the appellate court's got to decide is whether we're going to hear this appeal now. My gut, to be frank, is that they're going to, knowing what I know about the right-wing leaning aspects of the Georgia court system and the appellate court in particular, Judge Mercier being a Federalist Society member, I think this interlocutory appeal is getting granted, and that it will get fully briefed on the issue of whether Fani Willis will be disqualified. Let me just end it with this on this part of the segment. The case is not stayed at all pending appeal. I haven't even really, I've read through the 51 pages. It's not even something that I think is up for grabs at the moment, although at the appropriate time, we can expect Donald Trump's lawyers to ask for a stay. McAfee has made it clear he's not staying the case. So if you're going to get a stay, it's not from me. I'm going to continue to rule on these motions to dismiss the indictment, which got argued last week by Donald Trump's lawyers, that he has a First Amendment right to be a criminal. I mean, I'm boiling it down to its essence, but that is their argument, which of course is nonsense. But, there have been successful motions for demurrer and dismissal of certain aspects of Fani Willis's indictment already. The judge 2 weeks ago, dismissing 6 of the counts. So now we're down to 35 or so counts. The main one's still there. The engine driver of the indictment is the criminal racketeering, influence, and corrupt organization, or RICO count, which ensnares all of the co-conspirators with Donald Trump at the hub of the center of this wheel, right? So that's still there. So that all of his, so he may peel away a couple of more counts, but the fundamental argument by Steve Sadow on behalf of Donald Trump that the whole indictment should go bye-bye because he's got a First Amendment right to commit these crimes, I don't think even McAfee is going to side with that. So we'll have let's say by the middle of April, we'll have a indictment, a standing indictment that's maybe 33, 35 counts plus, including RICO, against Donald Trump. But he still hasn't set the trial date, despite Fani Willis asking for July. He may be waiting to get some guidance from the appellate court. So it's not a stay, but he hasn't set the trial date either. But and I'll give my final with the other moving parts of the trials that you and I are following so intently. With the April 15th start of the 6 or 8 week trial of Stormy Daniels' hush money case against Donald Trump, taking us into June, end of June, and then waiting to see what the Supreme Court does that we will be able to follow with audio at the April 25th oral argument, and them ruling about immunity and the DC election interference case before the end of their term in June, and they go away on their summer vacations to St. Bart's or wherever they're going to go. If that goes against Donald Trump, which everybody expects that it will, even with this right-wing court, then that trial with Judge Chutkan gets done in probably August, with maybe a month gap between Stormy Daniels' case, the hush money case, and this case I'm talking about. So there's no other time, frankly, for a Georgia election interference case before the November election, because he'd already be now in his second trial in August, which would take 6 to 8 weeks, which will take us till October before the November election. That is the optimistic trial calendar that we now have, and why Georgia, which we first thought was in the front and was the lead horse that was going to cross that finish line first, has ended up being now falling well back. You can tell it's Kentucky Derby season. It's falling well back in the pack as the first to indict, first to try case of the New York Manhattan DA case is starting on the 15th of April, and these other cases slot behind it.
Well, by optimistic, I think with respect to the Washington, D.C. federal case getting back on track for an August trial, it feels a little bit like winning the Powerball optimistic to me, because the math just doesn't math to me when you go back and you look at the fact that that case has been stayed since December, and you just do the math: December to January, January to February, February to March, March to April. April 25th is going to be when the oral argument is. You're not going to get a ruling from that Supreme Court on April 26th. You'll probably get one in June. April to May, May to June. That's a 6-month additional delay.
But she's not doing that. She said she's only going to add 90 days. Judge Chutkan has said she's going to add 89 days to whenever she gets the case back.
Michael Popok, Very optimistic.
Okay.
Very optimistic. Look, we'll see what the Supreme Court does in and of itself with this
Right.
dynamic, but I think it's a very optimistic projection.
All right. Intricacies of appellate law. Gets the juice flowing, gets the blood boiling. We do it one place on a cheekily named podcast we call Legal AF. We do it on Wednesdays and Saturdays at 8 p.m. Eastern Time, only on this YouTube channel. Help them get to 3 million free subscribers. Oh my God, it's the network that you've been waiting for and that you're building with your bare hands, as we are, on the MeidasTouch network. And then you can pick up a Legal AF on audio podcast platforms, whatever your pick your poison, whatever your pleasure is. So if you know all about Legal AF, maybe you just missed the last episode. There's a clip of one of the segments just to remind you what we do there, or help us be part of the marketing team. Take that clip, send it off to friends and family and people in your life and say, hey, Legal AF, here's a clip. Maybe they'll join our audience. That would be fantastic. If you have no idea who I am or what I'm talking about, and that is a distinct possibility, even on the MeidasTouch network. I'm Michael Popok. That was Legal AF, and we invite you to join our audience and be part of our movement right here on the MeidasTouch network and on Legal AF. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
It's Ken Harbaugh with the MeidasTouch Network. The film Against All Enemies, which I co-produced with Ben Meiselas and this network, has won awards around the world for its up-close portrayal of America's insurrectionist movement. It premieres in the U.S. on March 29th on Amazon and Apple TV. Go to againstallenemiesfilm.com or click the link below. But don't just watch Against All Enemies. Tell your friends about it. It's one more way to hold accountable those who threaten our democracy. Thanks, Meidas Mighty. Let's use our power well.